yeah, so it's just meant to say we can do things. I don't believe we have to be anyone super special to make a difference. And that's something I believe very strongly. So I run the Believe organization, and it's meant to encourage us to do small things, meaningful things, day-to-day things, as well as to recognize we can do big things and work on those. So that's a large part of what we work on. We work in politics, we work elsewhere as well. Utah, I believe, is on an interesting trajectory. I feel we've kind of lost sight of maybe the reasons we have law, and we're just starting to use law for whatever we want it for. And I think it will potentially lead to some bad places. But there's obviously good things in the law as well, some necessary things to address. And so the goal tonight is just to go through, learn a little bit about how the law is written. And we'll go through just actual legislation that's coming down the pike starting next week. And see if you can start to understand a little bit more about the law. But if you have topics you want to talk about, if you have bills you want to go through that aren't here, we can just pull them up and go through them. And then from here on out, starting next week, we'll also do a weekly online call to just go through the bills that have come out.
What's it going to be on?
It'll most likely be on Tuesday. That's what it's looking like right now. It'll probably come out to be Tuesday. So I'll send an email out on that. So if you want that email, make sure you sign the email list at the back to get that.
Would that be evening or during the day?
Right, it's looking like it'll probably have to be during the day. Just with all the crazy schedules going on. But those will also be recorded. But if you have a bill, even if you can't make it, you can send it and I'll go through it. And then we can also, put that up, or you can just call me if you have a question about a bill. Because you can just give me a call and we can talk about a bill if there's anything of particular concern. So any questions before we get started? Concerns? Okay, so we'll get going here. So I know we mentioned this last time, but this is one of my big mottos, that it's not enough to be good. You must be good for something. And you must contribute good to the world, and the world must be a better place for your presence. To me, that's one of the big purposes of life, is that we strive to do something. And with the legislative session, your efforts can have a very long-term impact on the state. The laws that get passed or that don't get passed will really shape a lot of things moving forward. So hopefully you can work on that. And then I fully believe, as an attorney, that you are capable of understanding the law. I'd say most of it. There will always be a couple questions. Even attorneys will call other attorneys sometimes and say, what does this mean? So you'll never understand everything perfectly, but you can get a lot of it. And most of the time you can catch what it's trying to do, at least, and identify if it's an issue or not, even if you don't understand every word of it. So when we talk tonight, I just ask that we have respect for each other, be civil, share your beliefs and opinions. I love hearing what people think. If you disagree with me, tell me. I have no problem with that. But particularly, I just say we have the spirit of listening to learn and not to just attack. So in the law, the judges call this statutory construction when they look at what a law means. And again, one of the things to understand about the law is the reason the lawsuits exist quite often is because attorneys don't agree on what the law means. And they have to go to a judge who decides, and then that judge gets appealed, and those judges feel differently on appeal. So again, this is part of this process of understanding that judges are going to say, we have rules that we go through for how to interpret law. And when we look to certain things, when we don't. And I think one of the important things to understand too about the law is you can read it and you can go, wait, this isn't clear. It's missing something. That happens frequently. And that's one of the big problems with law. If the law is not written super well, it will be missing something. And you may, as you go through it, say, this doesn't make sense. This piece is missing, and you may very well be right, because that's commonly happens. And so that's another piece where you can have a lot of influence to reach out and say, hey, you didn't address this whole thing. It's just wide open, or there's an ambiguity here, or these two things conflict with each other, and you should clean that up. And generally, things like that are pretty well received when you're helping to clean up a bill, or to point out inconsistencies. I can try to. My voice is very quiet. If you want to come up closer, you can too. I have it's one of my weaknesses in life is a very soft voice. So, but I will try to project a little more. So the first rule of statute, oh, go ahead. Correct. So I'm going to try and do better tonight. Remind me if I don't. I'm going to try and repeat the question for the video. Question was, will there be a PDF of the video or a PDF of the presentation too? I don't have a place to post that online, but if you want it, just email me and I'll send it to you. So I'm happy to share. First principle, though, of statutory construction is that all words matter. So the judges believe that if they took the time to write a word into the law, it's going to mean something. So when you're reading a bill, you can't just go, oh, that doesn't mean anything. It's just extra words. Every word matters. It's common in English. It's common when we write for us to say a bunch of things that we don't need to say. But the judges presume that all words matter in the law, and they will attempt to give every word meaning. So if your proposed interpretation of a law is saying that, oh, it just must mean that this sentence doesn't matter, the judges will say your interpretation is therefore wrong. You have to have an interpretation that takes into account all words. What's it? And this gets a little bit funny. We'll see some ways this isn't true. Another thing to remember about law, all rules are general rules, and there's an exception to every rule. So don't take everything as gospel truth. Even the Constitution says it's the supreme law of the land, unless a judge decides otherwise, right? So it's just, there's always exceptions there. But generally, shall means mandatory. So if the law says you shall file your taxes, it's stating a mandatory duty. You don't have a choice. You have to do it. Or else, generally, if it's a well-written law, there's a consequence for not doing it. If it's a poorly written law, it will say shall, but won't have a consequence. And so then, again, you have the question of, well, if I don't do it and it says shall, what's the consequence? And that could be a wide open question because they didn't write it in. And a lot of the laws in Utah, they don't write consequences for. And guess which ones those are generally? Elections, ones that govern the government. Here's the things you should do or shall do, but we won't say what happens if you don't. So there are a lot of laws that miss those things. May generally means it's discretionary. This is probably one of the most, I'd say, a very large source of contention for people. They reach out to me often. They're upset. They say, look, it says that the officers are supposed to do this. And I go to the law and I say, it says they may do that. They don't have to if they don't want to. So a may is something that generally grants permission, but doesn't create a requirement, and they have discretion. And we talked a little bit last week about how they can choose what they do or don't do. That's especially true with discretionary laws and things. And so when you're reading it, you can see that. Now, when you come across may not in the law, an officer may not do something, that generally means they don't have discretion, they just can't do it when it's combined with not. But if it's just saying you may do this, it's generally discretionary. And in the law will mean that two or more factors have to be met. So if it says If you want to get a driver's license, you have to be 16 and pass a driver's test. The and means both factors have to be met. If it says or, then only one of them has to be met in the law. And when you read laws, sometimes it'll list things. Boom, 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 boom. And you have to go all the way to the end to see the last bullet point to see if it says and or, to know if they're all required or if only one of them is required. Is how that usually goes. Again, read it in context. There can be exceptions to this. But that is a general rule. And then another weird thing about the law, it's kind of like math. Do you remember back to algebra when you had to find solve for x? And x was a variable? That could be 2, it could be 5, it could be 20. The law does that. It will create a definition, which is kind of like x. And it will define it. So it will say x equals this. And then they just use x all throughout their law. But they give x a name. They'll say officer. But they'll tie a definition to officer so that whenever they use it in the law, it doesn't necessarily mean what normal English means if there's a definition for it. It becomes one of those X variables. And the reason they do that is because if they ever amend that law, they can change the definition simply, and it changes everything all throughout. And we'll see some examples of that in some of the bills we look at tonight. And so sometimes when you read a bill, for example, a common one is employee. They'll use the word employee, and you think, I know what employee means. But it can mean whatever the law defines it to mean. It doesn't have to follow normal English. And I'd say that often it kind of does. You at least have an idea of what it's talking about, but there's sometimes it's quite surprising what the definitions are. The only way to know if a word's defined or not in law is to look at the definition section. And generally, every law begins with the definition section. You won't always see that in the statutes that they're amending because they only show the part they're amending. And so if the definition section is before that, you won't see it. You'll have to click into it on the website, and we can look at some of that too. But you always want to check the definitions to see if the word you're looking at is defined or not. Because that, if it's defined, that definition controls. If it's not defined, they'll go to normal English usage of the term with it. And then if there's two parts that might conflict, so if there's multiple ways to interpret something, and one creates a conflict in the statute and one doesn't, the judges will go with the way that doesn't create a conflict. So this is one of the big things about when Phil Lyman was putting out a lot of his interpretations of the law. They were choosing a lot of interpretations that created conflicts, and those aren't the ones the courts will follow. The courts will look to the meaning that kind of creates a cohesive interpretation throughout the whole thing. Is what they generally do with that. And then if there is a conflict and you can't resolve it, and the judge has to choose which part of the law is canceled by the other part of the law, because sometimes there is an irreconcilable conflict, they will take more recent additions as changing or amending previous things. So then you have to look at the actual time when the statute was amended. You look at its history to say, when did which part come in? And the more recent part is going to create the meaning if it's conflicting with the past part. Because they'll assume that they were trying to amend and they just forgot to change something. It was an oversight type thing. Any questions with this? And again, we're going to try and go through some of these things so you see it in practice. But let me know if you do have questions on it. Let's see. And then another thing that judges say, they say if the words are clear, they're just going to go with the meaning, even if it's a bizarre meaning. So if it just says, you can only run on Tuesdays, they'll say there's really no question. You can only run on Tuesdays, even though that's crazy. If the law is ambiguous, and it's poorly written, so you can't really figure out what it means. Judges will generally look to what they call legislative intent to fill the holes. They'll say, we want to know what the legislature was trying to get at. So in Utah, you can actually go back and watch the debates they had on bills and the discussions. You can go back to the committee meetings. You can see the floor debates and things. And the judges will turn to that to say, what were they trying to accomplish when we interpret this law, if it's something that's ambiguous. They will not look to legislative intent if the law is clear. Even if you can prove that the clearly written law goes against the legislative intent, they won't look to it because they'll say, the words are clear, we just stick with those. So intent's only relevant if they can't figure out what the words mean, or if there's a hole that they can't quite reconcile. Okay, so we're going to jump over now to some examples. And I tried to pick some bills that may be of interest to you as well when we go through the examples. And again, if you have certain things you really want to look at, we can pull those up too. All right, here we are. So this will be interesting here. We have the time change amendments. And Utah is proposing, we'll just look at this. So you see here, definitions. They're defining mountain daylight time, it's in quotes, so that's a term, that's the X term, that they can make mean anything they want. And the mountain standard time.
In code?
Red is not currently in code. Red are the proposed additions.
Isn't the red that? The red is the total.
Addition. Yep, so this is all new right here. If they're cutting something out, they'll strike through it and it'll be in blue. But it'll be, you'll have instead of a line under, you'll have a line through the middle. If it's in blue. So this definition, again, this is fun. This is where the law gets super fun. Mountain Standard Time means the observed time assigned to the Mountain Time Zone in 15 USC section 261. So the only way to really know what Mountain Standard Time is, you'd have to go to that federal law and see what it's talking about. So laws will often do that. They'll say, we define it based on this definition, based on this definition. So one of the things that means whenever you see something like this, one flag to know is that if the federal government changes its definition, it will change this law immediately as well. So when Utah chooses to reference a federal statute in a definition, they're giving the federal government power to change that law without Utah doing anything. And this, so to me, the preferred drafting method to maintain state sovereignty is they just copy what that section says, because they can just go there and copy it and put it in. And then if the federal government changes it to something weird, Utah doesn't automatically change it. They still has its own definition that's separate from it. But you see this a lot. And there's some bills and some laws they've passed where it's very concerning, where they adopt some definitions that the federal government could change and have regulatory ability over quite a broad scope of things. So, yep, go ahead.
How do you get to know what that code says?
Okay, so the question is, how do you get to know what this code says? What you would do is you would just go and you would type in 15 USC. Am I typing this right? 261, was it 261? Maybe not.
Yes, it is.
Okay. And you can go to Cornell, usually has really good up-to-date laws. And you would come and this is then you'd see what it says here. You could tell this was written quite a while ago. It's not been updated. I don't think they would use this term anymore. But that is the law there that it's referencing. So sometimes when you're trying to understand the law, you have to do a couple jumps for sure to see what is really going on. Let's see here. So this one, well, so this one happens to show us our definitions. There's only two terms. I think they're following our normal understanding of them, based on what I can tell. And then this is always fun when a law starts this way. Except as provided, so it means there's an exception. We're letting you know that right away. Again, the law likes general rules and they don't have exceptions. So this law says, beginning on January 1st, Utah is exempt from the provisions of this section that provide for the advancement of time by 1 hour. So I looked it up. This is the one that creates daylight savings time, where we move forward, spring forward. And it says, will observe Mountain Standard Time at all times of the year. And then it says, if federal law is changed to permit Utah to observe Mountain Daylight Time at all times of the year, Utah will, beginning on the January 1st after, follow that. This is a pretty simple one. They didn't use the word shall. They could have. They could have said Utah shall. They chose to use the word will. So will is often mandatory like shall, but will is a little bit looser on whether it's mandatory or permissive. But they chose that for whatever reason. So questions, do you have any questions on this basic one? Again, I started simpler one to show us the definitions and to show you have to reference other laws at times. Do you guys like that? Moving to, let's see, which one are we moving to? We'll observe Mountain Standard Time. So essentially we would stay on daylight savings is what they're proposing.
Apparently that's our only choice, that's changed.
Yeah, and that's, if you look at that law, that's, they don't allow you to observe, oh, sorry. No, standard time is the normal time. So non-daylight savings time. And yes, they don't allow you to choose daylight savings time for whatever reason all the time. But you can choose to not move forward with it.
So that's like Arizona.
Yep. But they would also switch on January 1st if this goes through in 2026. So we'd have our, I think, what would we have? We have time change in April 20 or March 2025. And then it would change in October or November now.
Standard time, and then we just stay that way.
And it would stay that way. Yeah, I was just wondering if it would switch back, but now it would stay. So they should have just said November, whatever, it would switch. But yeah, that's a big topic for whatever reason. Talking about that a lot more than we used to. This one's interesting. So I guess another thing to know about bills when you're looking at them, the law won't necessarily have this. If you're looking at actual law that exists, they don't have titles. I mean, they kind of have titles, but not like this. And they don't have summaries like this. But this gives you a summary of what's going on. And you see some of this. This one doesn't say definitions, but it says as used in this section. And this is another place where I think people get confused sometimes. This section is referring to just this 207 provision. If you're in 208 or 209 and you read the word employee, it doesn't mean the same thing. So again, you're going to have the term employee in 207 means something different than in 208 or 209, because this is only a definition for this section. That's it. And now you'll see some definitions sometimes that say for this title. The title is 53G. It's a big thing. Sometimes they'll say for the chapter, which is chapter 10. So all of chapter 10 has that definition that applies. Or sometimes it's just this one section. So here, employee means two things: administrative personnel and instructional personnel, and they reference other definitions for that. So again, you get to go to those and see what those might be. Now you can, one fun thing about Utah is if it's a Utah law, they're pretty good about putting in a hyperlink to it. Federal law won't have a hyperlink like the one we just looked at. But you can click on this, say, I want to see what administrative personnel is. And we have this here. So administrative personnel means, and you can see it's a broad definition. So it says means any LEA, we have to look up the definition of LEA or state board staff. So or means it could be one or the other. They have system-wide, LEA-wide, or school-wide functions and who perform management activities, including, and so this including is talking about management activities. It's saying that developing broad policies is a management activity and executing developed policies is a management activity. To drill down a little bit, it tells us some of who it includes. So then it goes into, say, school superintendents, assistant superintendent, cabinet members. So if you're looking to know if a specific position is part of administrative personnel, if they're listed here and includes, you know for sure it is. If it's not listed in there, directly in the includes, you then have to see if it falls under this kind of general definition. Would this person have management activities essentially to know? And then they have the instructional personnel. So when we look at instructional personnel, we're talking about, instructional personnel includes community volunteers. So an employee includes a volunteer under section 207 that we're looking at. And you wouldn't think that normally, right? But based on the term definition employee, it's wrapped into community volunteers. With that.
So on that part B where you have A, B, and C, where B says or.
Yeah.
So does that mean A and B combined or C?
Yeah, good question. So the or, they only put the or at the very end of a list. And an or means that only one of these has to be satisfied, A, B, or C. If it said and, then all three would have to exist for it to be counted. But yeah, good question. So some of these lists will be super long. And you have to scroll and scroll to know if it's inclusive or exclusive, because it's always at the end, it'll say or and. And the law will not say and or. I've never seen that. But it say and/or, because that defeats the purpose of saying one or the other. You don't know if it's inclusive or not at that point. And so instructional personnel here, one of these or one of these type thing. So that, again, in Utah law, when you're looking at it, they'll often, at least in the bills, they'll hyperlink. The law won't always hyperlink, but they try to be pretty good about that. If you want to see what LEA means, you can see that LEA is in a whole different title. It's in 53E instead of 53G. And so they're kind of bouncing around in their definitions with this. Okay, we will look at LEA. We come down, let's see. Here it is. So it's usually in alphabetical order, but LEA is the second thing here, so it's not quite in alphabetical order. But when you're on this page, if you can't find it, you can always do Control F on your computer and just type in LEA and it takes you right to it. So again, we have this LEA, local education agency, school district. So I live in Murray School District. A charter school. So one charter school is its own LEA, as opposed to something like Granite School District, which is a very large LEA. Or, so it's one of the three, Utah Schools for the Deaf and the Blind. So a private school is not an LEA. So this bill, if the bill says in it, LEAs shall or LEAs may, then you can look at it and go, well, it didn't include a private school, so this bill is not regulating private schools, unless it says an LEA and a private school. And so that's another thing to try and understand the scope of a bill, is to say, who is it regulating? So it's regulating one of these three, and the others are not regulated by it. And it can be concerning at times for people when they read a bill, because they go, oh, this is going to apply to all these places. And then you have to check the definitions to see how far or not that is. Let's see. And this one, again, it gets a little sad. So when you're reading this bill, we're still in the definitions as used in this section. It says required technology. And it gives a definition for what this means. We won't read it right this second. I'll show you in a minute why we'd come back to it. So we're here. So number 2, line 47 is where they start telling us what this bill's about. The law is saying an LEA or the state board, so they're regulating 2 things now, may not sell or otherwise transfer an employee's work-related contact information to a third party. Now, one of the things to understand about a law is whenever they propose the law, why are they proposing it? Because it's usually happened or been threatened to happen or something. So what I gather from this is schools are selling employees information. And you go, wow, that's not a great thing. Doesn't sound good, right? And so, but it says may not. So some people go, oh, it's permissive, but with the word not, that just means we've taken away all discretion. You can't choose to do it. Is what that means here. They could also say shall not, and it would mean the same thing in this situation. Shall not or may not would mean the same. And then number 3 says an LEA or the state board may not distribute an employee's work-related contact information in a manner that would interfere with an employee's ability to access or use work-related accounts. And it goes on to a few things. So sometimes, so for example, contacts, lawyers may have some strange situation where they go, well, what's a contact? It's not defined here. And the judge would say, well, how do we normally use this in the world? And contacts probably mean the people in your phone, that you're trying to call or whatnot. But again, there may be a reason where that gets relevant. We can't always predict those, so there'll always be something in the law we don't fully drill down on. This one though, number 3, I honestly, I was trying to think of a situation where you would distribute work-related contact information, and that makes it so it interferes with your ability to use your work accounts. I didn't understand what I was talking about. So when I looked at that, I was trying to imagine the scenario, and I didn't know what scenario I was addressing. I don't know if any of you have ideas of what someone might be doing that's now interfering with my ability to access something. Does it mean they gave my login to someone else and someone else is using my account? I wasn't sure. So if I were a school regulated by this, or if I'm a business that's getting regulated, a charter school or something, and I look at this and I go, what in the world is it talking about? What am I going to get in trouble for? I need to be reaching out to the reps and saying, what in the world are you talking about here? Because we need to define this more. I don't know what kind of conduct you're making illegal. Again, when I look at that, I don't know what that's talking about. So I don't know if you have ideas on that, but we get to number 4 in a minute. So this is where we get to required technology, that term. So it says an LEA may not require an employee to download, install, access, or otherwise use required technology on a personally owned electronic device if use of the required technology contains terms, conditions, or data sharing provisions that would allow for access to data or information outside of the required technology. That's a mouthful. So to understand required technology here, we have to scroll back up. We have to go, oh, required technology. And this means something they're making me use for my job. So the LEA said you have to use this to complete your job, whether it's time tracking, whatever it is. They define work-related contact information. That was in number 3. They did not, though, define personally owned electronic device. So they're just relying on normal English for that, because that was not defined. And so, to me, what this is saying is you can't require an employee to use an app that is going to collect information from their whole phone. The app has to limit itself to collecting information only from the app if it's required for the employee. I think that's potentially reasonable. Now, the schools may go, well, we can't use any apps then, because they all collect information beyond the app itself. And that would be something where the schools and getting regulated would have to call up their IT guy and go, hey, do our apps comply with this? Or are we going to be out of compliance as soon as this passes? And the schools then have to jump in and say, whoa, you just don't understand. There's no apps we can use that would shut us down if this were the law. Or, okay, it's fine. We've got apps we can use type thing. Often the legislative reps have ideas. They throw something out and it's up to people to say, whoa, 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 whoa. That's not how the real world works. You're going to shut everything down. And that type of feedback to them is very valuable if that's going to happen. And then this one in number 5 says, if an LEA requires an employee to use required technology that the employee reasonably finds to contain objectionable terms and conditions, the LEA shall, so this is saying the LEA has to at this point, they have to provide reasonable accommodations to the impacted employee to avoid mandatory use on the employee's personal device. The law then goes on, it didn't define this term, reasonable accommodation, but it says, let's see, it says some things that could count as a reasonable accommodation. So it gives some examples of what they could choose to do. Again, they do an or. So they could say, LEA, just give them a device to use it on. You can make them use an objectionable device or objectionable app if it's not collecting their own data on their own personal device. Give them a device to use, and then you can do whatever you want with that type thing. So it's giving them some steps they can take. Now, again, in trying to deal with this law, if you're willing to comply with this, but you say, hey, what about a 4th option? Can you just put that in there so we know it's good? The drafters will probably add that in if you reach out to them, if it's a reasonable 4th option. And that's a place you could definitely help out. And then it says an LEA may not take adverse action against an employee for exercising rights and requesting reasonable accommodations. And it says an employee may file a written complaint. So the employee gets to choose. They don't have to. They have the right to. They don't have to. They can file a written complaint. But the state board, if they get a complaint, it says shall investigate. So they at least have to conduct an investigation by law if a complaint is filed about it, if this passes.
Although there's no penalty if they don't.
There's no penalty if they don't. So what do you do if they don't? And that's, again, when you look at the law and say, okay, because that's an important thing to ask in the law is, oh, okay, there's a shall. What happens if they don't? And this is where the Utah government loves it. Like, oh yeah, sue us, pay a bunch of money. Maybe a judge will tell us to at some point, maybe not. And this, again, makes people very frustrated because they'll see a shall, they'll say the government has to, and they're choosing not to. And there's no penalty. So again, a good bill would have a penalty or an enforcement mechanism. Utah is very good about leaving those out as it relates to government.
What would be a good one for this?
To say what happens if they don't. I would say if they don't investigate, the employee gets $5,000, something like that. Like then they have a huge incentive. It comes from the board's budget. Now, something like that. If you hit their budget, have an automatic because there's some things, if they do say in the law that if the governor doesn't veto a law within 10 days, it's just considered approved, even if he doesn't sign it. And so I can say, well, we could do similar things if you don't investigate, you don't step in. Must be a valid complaint. They get what they asked for. Or maybe there's a cap or something like that. But you have to have some incentive for them to step in and do something. The only thing would be if everyone starts to file a complaint and there's thousands and they can't get to them. That they'd go, well, what if that happens? They will write something in. Write in that it was a certain amount of time to investigate. They got to get to it. If they're overloaded, they can file for an extension, whatever. Those aren't hard. These are just words we're writing. Drafting attorneys can write words pretty cheaply. And we can put in provisions like that. And again, whether it's proper to say they get what they're asking for or $5,000 or whatever, that, that to me, you can debate about that a little bit and go through it, but generally any type of enforcement mechanism that hurts a little bit, they will work for. Money talks powerfully. If you're losing your budget, you don't like that. So those are things that, again, are helpful to look at. And then it says shall investigate and, so there's an and, so the shall applies to this too. It says they shall take licensure or corrective action. But then again, this is where it gets it goes, this is an exception to shall, because then it says if they determine it's necessary to take action. So you can get out of the shall by saying, oh, we investigated, we don't feel any actions necessary. So it's a mandatory, and then they take away the mandatory with the if. It's just, I don't know. This is the fun of the law.
It gives you a way out.
Yeah. So those are, and again, there's all these little words. These little words often change tons of meanings. Ifs, ands, ors. You look at those. Any questions or comments on this one? I guess, do you think this is a good thing? Bad thing?
They did it, there was a consequence to it.
Yeah, I think I like a lot of this stuff. I'm a fan of privacy. I'm a fan of employees not being required to use work-related things on their personal devices. Sure. But yeah,
It feels like it's just kind of like a cover to that, yeah, we're gonna act on it, but.
we don't have to. Yeah.
So it leaves you warm and fuzzy, but.
Yeah, and a lot of, again, this is one thing to be aware of with bills. They will propose bills to make you feel warm and fuzzy. They don't really change anything. It's kind of like saying we're going to get tough on crime by making this go from 5 years to 10 years penalty or whatever in jail. It's like, well, is that really going to make someone go, oh shoot, I'm not going to do that anymore? It's 10 years now. Those are generally feel-good bills where they're up there posturing that they've done something and nothing's going to change in society as a result. Now, maybe if you took speeding from a ticket to 10-year felony, that might change something for people. So there are some things that could. Yeah, there's a whole side to that. We have a lot of private jails and they make money based on people in them. So they may want some of those. The last one? Let's see, it was HB 124. Okay, this one's really interesting. So they've had the issue with, so one thing too, again, with a bill, you always want to ask what's happening. Sometimes you don't know. Sometimes you have to do a little research to try and understand the context. This one, they have some states where people have figured out some loopholes in the eviction laws. And for example, if you're a guest at someone's home, sometimes based on the situation, they have a hard time kicking you out if you refuse to leave on your own. And so there was I clerked for a judge in Michigan, and the case came before us. It had been over a year. And these people knew the laws very well and the loopholes in them. And they had one person sign a lease for it was a pretty expensive home. At the time when I was in law school, it was, I think rent was $5,000 or $6,000 a month for this home, which was very significant for the time. It was a huge house. And the one person signs, they move in and they never pay rent. So they start the eviction process, they notice up this person, they do all these things. In Michigan, it takes at least 9 months to evict someone. And they go through that and they get to the very end and the people say, oh, guess what? There's someone else living here and you never sent notice to them. Got to start all over. And they know that they can just sign up for a lease and get 18 months at least rent free for these homes. And so the judge comes in And he goes, Austin, he says, I am so angry at these people. He says, find any way you can to kick them out. He goes, I don't even care if it gets appealed. I want them out of the house today. And so I had to go through the law and try and find a loophole to the loophole to see if there was something where the judge could still kick him out. Because under Michigan law, you have notice and different things. But if you read in the news, it's happening in New York, Florida. People sign up for an Airbnb, supposed to be there a week, and then they never leave. And they're not quite a tenant under the law with the way the law is written and things. And so I don't personally have knowledge of this happening in Utah yet. It may have, I don't know, but it's certainly been on the news in other states. And so Representative Lisenby is saying they want to be able to get people out faster. Because another thing that will happen is someone will see that you go on vacation and they'll just put your house on Airbnb and they'll charge someone to show up to your home. And then you should come back from vacation and someone's in your home, believing they have a valid Airbnb to be there type thing. But someone else just listed it and took the money. So this goes through a lot of these things. And it's giving the sheriff the ability to kick people out faster. And so it goes through a couple things and it talks about, so it specifically references these terms, these definitions, and they say these words apply in this section. This is the third way to do it, where it's adopting other provisions and saying, yep, same terms here. So you got to go look for those X variables, see what applies.
The section is 106.2.
This one is 106.2, and it's saying that 101.5 and 101 definitions apply here as well.
106. It's not the 6, not the 76, but the 106. That's what a section is, the last one.
Yeah, the section's the last one. Yep. So title, chapter, section. Yeah. Is the way that goes. And just so you can see that, let me pull that up here. So you can see how they break that down in code. If we actually go to the code, it will list these titles. And so it's broken up broad stroke by titles. Utah's got 81 titles, even though it skips numbers in here. They're not consecutive. So there's no title 62, for example. So if you want to be a pioneer, propose legislation to fill in title 62. So yeah, you won't have all the title numbers there. But if you come to the title, that then has chapters. Sometimes it will say part. So some of these, when you click on them, let's see if any of these do it. No. They're not giving me part. Sometimes it'll say part, and you have to look into it. Maybe that's actually here. Let's see. There we go. There's the parts. So chapters may be broken into parts. These parts won't show up in the law citation. And so if you're looking at 76-1 and you're looking for 405, you go to part 4. So the first number of the section at the end is the part, is reference to the part. It can get confusing if your section is 1202, 1202. You might look at part 1, but it's part 12. It goes in hundreds. The way that works, you have to go down to part 12 to find your thing. But if you're looking for part 1, so something in chapter 1, we have the definitions here, 101.5. And they have all these different things that it defines. So you're here in 76.1-1.5. And they usually do a 0.5 because it kind of means they forgot it and they already used up numbers. So they already used 101 and 102. It should be at the start. So they say 0.5 to get it up there. Oh, and then one other thing, so we talked about, since we're here, we talked about needing to know the history of the bill. So they actually tell you some of the history. They tell you the most recent history when you look at the bill number. It will say when it was last amended and what amended it. So if you're trying to figure out changes, you can just go to the bottom of it and click on that. And it will take you to the bill that amended it. And you can see when a bill goes through and amends things, this is a very large amendment. it has the strike through. Now the bill's passed, the old ones, they don't do red and blue anymore, but the underline is added, the strike through is deleted. You can see in all of these, if I want to say 8-5-5 and know when that section was last amended, the bill that amends it will tell me again the last time it was amended. So the last time 8-5-5 was amended before this was 2007, chapter 329. I can go look that up. And you do this, and then you can see from there, it will show you the last time it was amended before that. And you can follow each revision back. And Utah has made that pretty accessible. Many states make that very difficult to follow through. Utah, you can follow it if you're willing to jump through some links to find it. Let's see. Let's go back though. So we're here. So this one does say a penalty. Why does it say a penalty? It's not regulating the government. This is regulating us. So there's a penalty here, and we know what happens. It's a felony. And the things I wanted to look at here, we aren't going to go through this whole bill. So this is one here. It says an owner of a residential dwelling may request, so they don't have to, but they can, that the sheriff of the county in which the dwelling is located immediately remove a trespasser occupying a residential dwelling. So to get someone immediately removed, usually you have to have a legal process to pull someone out of a property. And they're giving some teeth around getting someone out a lot faster without suing the victim. They have A through F. If you just start reading, you're going, oh, is this an and or an or? You go to the bottom one and you see and, or the second to last one. So all these conditions have to be met for this law to apply. If any one of them is not met, you don't have the right to immediately remove someone. So it says here you have to attest that the trespasser unlawfully entered, but they're still there. You have to attest that it was not open to members of the public at the time the trespasser entered. So if you hold a party at your house and someone refuses to leave, you don't get the benefit of this law. If you were just inviting the whole neighborhood over. Kind of unique. The property owner has directed the trespasser to leave, so you've said you got to leave. They're not a current or former tenant. This again is a little concerning to me. Why are we protecting former tenants? If you're a former tenant, you're a former tenant. I don't think you should. I think you should be able to be removed pretty quickly if you're a former tenant. But that's there. And then trespasser is not an immediate family member, and there's no pending litigation between you two. And related to the property. So if you're in a fight over the house, you don't get the benefit of this still. So again, interesting, the different situations that they're carving out. Part of it is because they're trying to preserve some due process for people that may have an ownership dispute or something in a property or whatnot. But that's what they're looking at. So you see the and there is operative. It says up here in A, they have to attest. And so this says right here, kind of what that attestation is like, what it has to happen. So they're going to make it so that there's no question. Because if they didn't put this in, you could just say, yep, I attest. And the law is saying, we're actually going to define it down a little bit to say what it has to include. So they go through and they say the submitted complaint shall be in substantially the following form. So shall be and substantially means it's got to be pretty close. It doesn't have to be exact, but it's got to be pretty close to this. And then these are the things you have to be able to tell the sheriff to get them to come act. There are 13 things. And this one does not have an and or an or listed. But it says from context, the complaint shall be in substantially the following form. If you're going to start taking pieces out, it's probably not substantially close. So it probably means and for all of them. But again, there's a little bit of wiggle room. If you were missing the date you purchased the property, Could they still do it? Probably. Most attorneys would probably say that's substantial enough. But if you said that the residential was not open to members of the public at the time, and you left that out, they would probably say that's not substantial enough to be compliant, because up here, it's a specific element that you have to prove that it wasn't open. So those are some of the things where it's a little bit more ambiguous in this bill, and there's a little bit more interpretation. And you have to go back and forth a little bit to see, what that is. But the sheriffs will probably have a statement and say, oh, you want to evict someone, they're just going to copy this from the statute and say, fill this out. And then it says, upon receipt of the complaint, the sheriff shall verify that the individual, yada, yada, yada. If verified, the sheriff shall, without delay. And again, what happens if they don't, or they do delay? Those are questions. The sheriff can charge for this. They can charge the same fee. Then it goes through a bunch of things. But it does say here, an individual may bring a civil cause of action for wrongful removal under this section. So if I kick someone out of my property, they can sue me if I didn't actually have the right to remove them. And then, again, they're really good about saying what happens between private people. If I kick someone out I wasn't supposed to, or I lied, they get statutory damages equal to triple the fair market rent of the dwelling. What doesn't it say with that? What important factor is missing? Big hole there. Rent for how long? You get a month's rent? You get a year's rent? You get 10 years rent? That's a huge, huge gaping ambiguity there of how long. And a court's going to have to figure that out and say, oh, well, let's see what's supposed to be there. But that's a big ambiguity. And then it says, if you do sue because you were wrongfully removed, it says the court shall expedite the trial and any hearing and action described in this subsection. So again, we see remedies all throughout against the individual, right? What if the court doesn't expedite it? Nothing. Do you think courts care about these things of you shall expedite this case? Nope. They don't care. We have cases, Utah law, I've had 2 now in the last couple of years, where Utah law says that a hearing shall be held within 14 days. And the judges wouldn't even talk to us to even schedule it. And it didn't get scheduled till more than 3 months out. And one of those hearings was over 6 months out. It's supposed to happen within 14 days. So courts don't care a lot. We don't put any mechanism in on that. So it's cute that it says it shall expedite it. No judge cares if they're busy. They're not gonna care. I can't say no judge. Some judges will. There are some judges that will really try to do that, but a lot of them don't. And then the bill also has an effective date of when it starts. So you could not kick someone out before May 6th or before May 7th. There. Questions on this or thoughts?
What does immediate family member mean?
Good question. So that's a great question to say. Immediate family member.
Like child,
Uh,
or would that be go out to like aunts and uncles? And
it would be interesting to see.
or like
Yeah.
spouse, like if a spouse was not supposed to be on the property.
So this one does not define immediate. But it also had 101.6. So it does not say immediate family here. So we would have to go to a dictionary definition of it if it's not defined. And immediate family usually means parent, child, brother, sister. There are other places. So one of the things you can do, even if it doesn't expressly apply, you can search. Let's say we're here and we just go up and search and we say, how many times does Utah use immediate family? You can see that they define it in HB 142. It's introduced. So this is limiting it to an individual spouse or dependent child. But you may go through and find out that they have defined it differently through different times. And if they've defined it differently, the court won't necessarily look to one over the other to see what it means. But this one's consistent with the other one, individual spouse or dependent child. So if it's consistent every time in Utah code that that's the way it is, the chance of the judge interpreting that way is pretty high. But you will, I had a case once where there was a definition and we pulled it up and I think there was something like 10 different ways it was defined throughout Utah code. So an employee will be one of those. If you look at the word employee in the definitions, it'll be all over the place as to what an employee is, depending on the law.
What we just, what you just read. So did you say that if you invited, like, had a party and someone, I guess, decides to just spend the next 6 months, you can't, you can't keep them out?
So, yeah, so the question, and I'm trying to remember to get on the recording, is if a guest comes to a party and they decide to stay this next 6 months, you can't kick them out. The law says you have to be able to say it wasn't open to the public. So you can have a party that's private still, or it was invite only. But if it's just, hey, neighborhood, come on over, open door policy type thing, you wouldn't qualify for this law. There are other laws to still try and kick people out, but it's a longer process. You have to move to evict them, follow eviction laws and things. This is an immediate removal. But you could have a neighborhood block party and someone just start camping in your home and you're like, I want you out today. Cop says, sorry, you gotta stay to a victim. So this law is not addressing all potential scenarios. For whatever reason, they've chosen to limit it to certain scenarios. And if you talk to the drafting attorneys and the sponsor of the bill, they'll probably tell you a situation, why it's important. And you can tell them some situations why it would be crucial to still let you kick someone out if they came over for a block party. So for example, at our house, we have Taco Tuesdays and we say, come on over. Anyone wants some tacos, come on over. And so, yeah, we wouldn't qualify for that law in particular. The question is, does Utah support landlord or tenants more? They support landlords way more. Tenants have very few rights in Utah. Utah has one of the fastest eviction statutes in the nation. You've got 10 days to get out, essentially, and the courts usually move through that pretty quick. They've kind of set up a landlord-tenant calendar, they call it, where those cases get just lumped, assigned to a judge who just kind of says evicted, evicted, evicted. It's not like Michigan, where it's at least 9 months to evict someone, or California. It's different. Did you have a question? I thought someone else raised their hand. Joe?
So is it a good idea to ask these people sponsoring these bills why they're doing it?
Yes. It's a really good idea to ask why, because if they don't have a reason, then we should fix it. And it's not uncommon for the drafting attorney to have written something in for whatever reason, and the sponsor just goes with it. But they didn't necessarily, most sponsoring representatives don't go through it in as much detail. They don't care as much. They're getting this fed from someone else or something else. And it's fine to say, hey, if someone's hanging out at my house, whether it was public or private, once it's over, I should be able to kick them out. Um, that's at least my, again, if you're saying immediate removal while it's open to the public, okay, I can't kick someone out immediately. I have to close the event down first, maybe. But yeah, but these are the types of things where we reach out, and this can be a big deal for someone if you ever find yourself in a random situation and you don't quite qualify, or your neighbor doesn't quite qualify, or your mom doesn't quite qualify. Cleaning up some of this language is very helpful. It makes a big difference with these things. So I support the general intent of the bill, but I do think there's a decent amount to clean up, especially on the statutory penalty of 3 times rent. What's rent? Rent can be a year, a month, a day. What is it? Let's see if I can get in here or not. I'm sharing my screen. Oh. No. I think that'll maybe I'll make this. Let's see. Put it at the bottom. Okay, adoption records. This one's really interesting to me. We get to see some blue with this one. So the blue, this is stuff we're cutting out. So it used to be that a birth parent could consent to allow access to their adoption records. So you could have open adoptions and things if you wanted to. One of the reasons the law has, they still adoption records. And if you've been adopted and your parents didn't consent, you can't get access to your adoption records. One of the reasons they do that is because it can be very difficult for people to think about having to meet a child 20 years later that they adopted out. And so they've guaranteed parents a level of privacy associated with it if they feel they need that. And one of the reasons is they feel that's necessary to facilitate adoptions. There's a policy decision, but they had the open adoption side where parents could opt in and say, we want our kids to know us, we want to have a relationship ongoing. We just can't take care of them. This law is actually cutting out a lot of the options for a birth parent to allow for their child have access to these records. Which I don't know, that was a little concerning to me because I'm a big fan of letting people choose if they want that or not. And essentially, so they cut out a lot of this blue stuff. And there's very little here. So essentially the gist of this is except as provided in subsection 3, so we have to go down to 3. Adoption and adoption document or any other documents are sealed, which means in the law you can't access them. So some of these things you can look up if you go, oh, what does sealed mean? You're not going to have a definition of that in the law. That's a legal term. But you can look up and say, what is a sealed record? And you'll get a pretty good answer online. So some of the times when you're looking at things, if you can tell a word has meaning and you don't fully know, Google it. There's some pretty good legal definitions out there online. And it doesn't hurt to check that. So it's saying it's sealed. Sorry, what's that?
What bill is?
This is, go up a little bit. HB 129. And then you come down and it does say that an order, letting people in can permit an individual described in section 3B. So you have to go up and see what 3B is. 3B. So it's talking about an individual intervening, I guess. So again, kind of limited situations. It says that they can get some of the information after the identifying information of the adoptive or prospective adoptive parent is redacted. So they're saying we can still give out some information if we redact names. So I think the intent is to give a little more, maybe, but it's also taking a little away. And I don't know. I don't know why we had to cut out all the stuff there. If we talk to him, he may say that the Utah government's having a hard time dealing with this, trying to figure out what's sealed, what's not sealed, all over the place. I don't know. But I don't know if I love this solution because it really limits it down. This one, again, is a little bit more complex to follow because there's a lot of subparts. You have to bounce around them and figure out what's going on. And sometimes you just have to make a little map for yourself. You say, okay, it says this, it references 3B, and then you just have to go write 3B. And so one way to do it is you can get a Word document and you can just copy the section and put it there and then put 3B next and then put 4BI and just kind of follow it through without scrolling back up and down. Each time you're trying to figure it out, just copy and paste it into your Word document to see each reference in order. Because sometimes it's up here, then it's down here, it's up here, it's down here. And that's something that helps if you make that little map as you read it. Thoughts or questions on one like this?
If I'm understanding this correctly, here, the parents that are letting a child be adopted have health problems. And that child sometime in the future wonders, their genetics. Does this prevent that?
And
Because
It says-
genetics would be to know who the parent is.
it says identifying information. A judge would probably hold genetics as identifying information. So it'd probably not release that type of info to them. But again, if you went to Ancestry and you did a genetic test and that those parents that put you up for adoption had other kids who did Ancestry, you may connect through that outside the court system, outside records. And that's happening. I have a guy I know that he did a DNA test with Ancestry and he got a call from a lady that said, hey, we're matched as brother and sister. We've never met. And this guy had no idea that his mom had had a child earlier in life and adopted it out. And so he found his half sister essentially. And that's outside the court system. That's through, consenting to Ancestry's sharing of your genetic information and things. So that may still happen. But this wouldn't be, you wouldn't get that information from the court records with this. But one of the other things that's interesting to me about this is any changes to this type of law, I look at and go, this presents an interesting constitutional issue, because if I make a promise to you as a parent and say, I won't give out these records, and then I choose to give them out just with a couple of things redacted, I'm going against my promise that induced you to put the child up in the first place. And that could still be concerning for parents. And so sometimes when you modify things like this in the law, there could be constitutional challenges to this from parents that say, whoa, I relied on that. You can't, maybe for a new adoption going forward, but you can't change past stuff. That's what's done is done type thing. And so I could see this law producing some consternation for some parents and maybe producing some lawsuits over that. And that's a thing to consider when you look at these types of laws. Questions with that? Or comments? This one, I put this one up here. Because again, you'll see this one gives you a little bit more insight into how changing the meaning of a definition can change the whole application of the law. Utah is really big right now. A huge political talking point is housing affordability. We want more affordable housing. So this is something that's aimed to help promote that. And what this bill is doing is, we come on down past the definitions. It says an institutional investor may not purchase single-family housing in the state. And then it's interesting. It gives a remedy, but I'm still curious of what you think about this remedy. An institutional investor that, in violation of subsection 2, purchases single-family housing in the state shall, so that's a command, shall alienate the single-family housing within 1 year of acquiring the single-family housing.
Oh.
So what is the effective impact of this law at most?
From year to flip the house.
You have a year to flip the house. But even beyond the year, now what happens? Oh, I held it for a year and a day. Oh, nothing, right? What is the legislature full of? Developers, investors, you know. Developers always buy their land and houses and things and entities. So it's interesting to me, but on the institutional investor side, we come up and say, okay, what's an institutional investor? Now this is interesting. They actually don't go in alphabetical order. So that's a drafting oversight. And so generally it's alphabetical order and definitions, but this one wasn't. So institutional investor means a partnership, corporation, limited liability company, or trust. Or any affiliate, subsidiary, or holding company of those entities. So if they had said, so you could change the whole application of this law by simply removing limited liability company, and suddenly everyone could circumvent this law by just forming a limited liability company. And again, it's only four things: institutional investor, partnership, corporation, limited liability company, or trust. So if there's ever any other type of entity that comes out, bank, if you're just a bank and you're not one of those things, if they have something like that or whatnot, then you may be exempt from this. It also says it means these things, but it does not mean an affordable housing nonprofit corporation, which they define up here, a family trust or a family limited liability company. And then it goes down, and again, it's defining things. And these definitions are creating the regulatory scope of how far out this applies, because the institutional investor that can't buy single family housing. But that doesn't include a limited liability company that has no more than 5 members, and each member is an individual or family trust, and each member is related to each member. This one, if you look up this term, you'll find legal definitions for that. I don't know if you've ever run across that word in all your genealogy, you may do, but third degree of consanguinity is blood relation, essentially. So I think a cousin is second degree, I believe, if I remember right. But it's saying you have to have close connection relation. And then it also has a thing about it's an and whose revenue is paid. And then it also defines a family trust. Now, there's a lot of concerns with things like this. You wouldn't know this from looking at it, but the fact that each member has to be an individual, it means that your entity cannot be taxed as an S corp. S corp taxation is far more advantageous to individuals and families who own property if they rent it out or any of those things. Many of them are taxed as an S corp, but S corps. Yeah, so sorry. So a lot of these will have additional. So if you have an LLC owning something and there's 5 owners, if I'm an owner, I might have my LLC on it, and my brother might have his LLC on it, and those are taxed as S corps. It's one of the ways that people generally do things to get tax benefits. You can't do that though, because each one has to be an individual. So a family LLC is restricted to no second level of corporate ownership, which again, if you weren't doing this, I do a lot of business stuff for people. It's very common to have at least 2 levels of corporate ownership for tax purposes. You start to lose some tax benefits and things with this law. This will impact a lot of Utahns. There's a lot of people that own property in LLCs and corporations because you do it for liability purposes, you do it for tax purposes, and you may only own 3 rentals, but this is coming after you. And another serious issue with this law, it creates a little bit of an ambiguity. It doesn't directly say what happens to all those that already own it. It says you may not purchase. So what's the other loophole there? Can't purchase the property, but you can hold it. You can have it transferred to you. And so I could buy a piece of property and just transfer it to an entity. So as long as any entity, it says it shall alienate the single family housing. I go, so I can come in and buy it, and as long as I just then transfer it into another entity for free, it wasn't purchased in the state. Pretty big loopholes in this law. But it's going to impact the poor individual that comes in and says, well, I want to comply with the law. The attorneys will say, well, it's illegal to buy this in your LLC. We can't do that anymore. And they won't. But the big companies still will. They'll ask their attorneys, well, what's the penalty? Am I going to get in trouble? What are the loopholes? And there's a million ways around this law still. And from my perspective, this only hurts the individual, the way it's written right now. The individual person that can't really afford an attorney to go through and sometimes the drafting attorneys know, sometimes they don't. Sometimes they talk to the people about it. Sometimes they don't. My take on this though is these are pretty big oversights to say may not purchase. There's a lot of other ways to get property, and it's common for businesses to transfer things and not purchase and whatever. So this to me seems to be an intentional loophole. And again, even this, well, what happens if they don't? And why give them a year? And
So what would be a better way to say that? Maybe we not acquire?
acquire, purchase, hold. Generally, you go through and list all the different things that could happen. You say, and you'll see this if you ever read terms of use online, the attorneys always say, any claim, any damages, any fee, they just list whatever could possibly happen under the sun. And you do the same thing, say an institutional investor may not purchase, hold, acquire, transfer, yada, yada, yada. But one reason I'm sure they didn't say hold is because there's a serious constitutional issue with taking property away from someone that already has it. Now, the way around that could have been to say this law applies to property acquired after the state. They didn't say that here. That would have been a very strong way to help the constitutionality. So part of me looks at this and says, it's a feel-good law that I think they intend for it to fail even because it doesn't even have the effective date. I mean, sorry, it has an effective date, but it doesn't say whether it's retroactive to existing ownership or not. And that's problematic. Now they may say, well, it doesn't apply. It's only if it's a purchase. And I go, well, that's not doing much then, other than making it hard for individuals. But again, what happens here? So you go past your year. I don't know. I'm not a fan of laws like this that are more for show. I feel a lot of the affordable housing bills are more for show, personally. And again, as an attorney, the drafting attorneys, they're trained for 2 years before they even get to draft legislation. And so there are some things where you could say, yeah, they may not know the S-corp tax status. They may not be trained on that. But they know purchase. I think they know there's other ways to get property and hold property. That's my take when I look at it. So when I read it as an attorney, I can certainly have an opinion about what's intentional or not, because there's some just super basic things that are missed. Now, again, it may not be the drafting attorney that the sponsor could have said, I only want this, and they'll draft what they want. So we don't know where that is. But the fact it's not there means to me it's intentional. Someone took it out. And it was probably the sponsor. This is another one on affordable housing. And this is interesting. So this one has affordable housing nonprofit corporation. Remember that? We just saw this definition. It was incorporated for the purpose of providing affordable housing. This one had this definition too. And it's interesting that they're both using a definition without referencing each other. One reason they may not reference each other right now is because one of the bills may not pass and one could. So then you'll have two, if both pass, you'll have two definitions following each other. Or, sorry, you'll have two separate ones. But she's looking at her things as saying, in essence, there's a lot of things to find here. She's saying that a purchaser may not enter into a contract. So the buyer can't sign to purchase a single family home in the first 30 days after the day of listing, unless at the time of closing, the purchaser signs an affidavit of intent to occupy. And so this is defined, I think, up here. Affidavit of intent to occupy. Again, this is just, it's a long definition. But generally, the only way you know what the definitions are is you have to read them. You go through and identify, these are the things that will pop up. And if you're using, so you can download these two as a PDF over here. And if you do that, you can highlight them. You know, if you have the PDF functions, you can highlight a term, and then you can do Control F, and then just highlight each time it appears, so that you know, you remember as you're reading it, okay, this is a defined term type thing. That's one idea, if you want. But they're saying that essentially,
What's the county of the first class?
good question. County of first class is defined in the law, it will be defined elsewhere. The county of first class is a county that's a certain size. We only have one currently in Utah. That's Salt Lake County. So Utah passed a bill a year or two ago to regulate prosecutors' offices in counties of the first class in Utah. And it was to regulate Sim Gill's office. No one else's, but they did it under the guise of counties of the first class. So, but Salt Lake County is the only one that's big enough to qualify. But this is, again, this is interesting. And then the other one is saying that you can't contract entered into on or after May 7th. Again, so this is talking about a specific contract. It's not going to avoid everything. So you can see here, they included it here. It's going to apply to contracts from this point forward. It's not going to undo previous contracts. They didn't mention that in the other bill. And you can come up and you can say, you can look and say, let's see, drafting attorney, Austin. It's not me. And drafting attorney. So there are two different drafting attorneys, which is interesting because these are two very similar topics, and they usually give them to the same attorney. This is proposing to enact 57-1-48. And this is proposing to enact 57-1-48. So two attorneys are competing. They didn't crossball on this. They're usually supposed to flag these things to say, you know, one attorney drafted the same thing, one attorney drafted the same thing in the same code section. If both get passed, they have what they call a reconciliation period, where they try and marry it all together and make it work, and they'll change numbers and things for it. But if you could see, though, the reason I looked at the drafting attorneys, if it was the same drafting attorney and one had the date and about it's not retroactive and the other one doesn't, it's very clear it's intentional. Here again, it's two different drafting attorneys, so maybe one's newer. I don't know. But she doesn't want you to be able to do a bulk foreclosure sale, which is the sale of two or more single-family homes in a single transaction to one or more buyers and property that's been subject to mortgage foreclosure. So what was happening is the banks have their properties they're getting foreclosed on, and instead of selling them one by one and giving individuals a chance, they're like, oh, this takes a long time. There's 30. Who wants to buy all 30 at once? And the only people that could buy it were the big investors.
How would this law then go outside of Utah?
It would, well, the law would apply to any buyer that's purchasing a Utah property. So if you were a New York buyer,
They own the property.
once they foreclosed, yeah, once they foreclosed, Utah gets to regulate Utah real property regardless of where the owner lives. So if you go buy property in Colorado, that property is subject to Colorado law, no matter what. No matter where you're from. So this is saying you have to sell foreclosure homes one at a time to give people a chance to buy it.
So I'm not selling them to that child.
Correct. Well, you could still one by one sell into hedge fund under this law. But it's to make it so that at least I have a chance to bid on it, because I can't bid on 30 homes if it's a bulk 30 home sell. But I could bid on one home and bid again and bid again and bid again until I get one. So this one, I think this is fine. I go, sure, put them up for auction one at a time, let individuals have a chance.
Where it says-
Yeah, so this one is saying that you can't, what it's designed to do, I read about this one in the news, what it's designed to do is make it so that an individual has a chance to bid on a home within the first 30 days. So as soon as the home goes on market, the big hedge fund says, I'll give you $500,000. They're saying the hedge funds can't bid essentially till 30 days have passed because they can't sign that affidavit of intent to occupy.
The people that actually want there in the home for the first 30 days,
Then after anyone can, yeah. So so when you're looking at the law and again, trying to understand it, what's the practical impact of this law? What happens to the Utah real estate market with this law in place? Do you believe that individuals, so just this part, don't worry about the bulk sell. The bulk sell might help someone get a home. On the foreclosure thing if they can't be bulk sell. But just this part, is the 30 days going to help someone get a home?
only if somebody has to sell immediately.
Only if they have to sell within 30 days, right? What's it gonna do otherwise? You're just gonna put it on the market and know you have to wait 30 days to see what bids the highest. So to me, this law, its impact is only going to say, because if you're like, oh, I got a bid, I might get more, it's worth waiting another 4 weeks and seeing. You can wait. And now the individual homeowner could try and put pressure on. They could say, my bid expires on day 29. And then you have to guess if you're going to get more or not. But you know, the investors could still talk to you. They can still say, oh yeah, we'll offer you this. So to me, it just puts a 30-day extension into the home buying process. And I don't know that it actually gets anyone a home unless the person has to sell for 30 days. But even then, there is an exception listed in here for, say, exigent circumstance. So you can have an exception to this if you have to. So
That's hilarious.
So I don't, again, to me, these are kind of window dressings that people want affordable housing. So here's the solution. And, you know, I think people just might be more upset if they wait 30 days before they know fully what they can and can't do.
I feel like when we bought our house, if you didn't live in it for over 2 years, you had to pay a higher tax bracket or something. Did that get taken away, or
No,
these companies just not care?
the companies never qualify for that anyways. So what it is if you buy a house and sell it and you make money on that, you owe capital gains tax on that gain. For a business, they have to pay that every time they sell something for more than they bought it for. They're paying capital gains tax. For individuals, the federal government said, we'll exclude the capital gains tax on your primary residence. So if you only own one home and you lived in it for 20 years and it appreciated, we're not going to ding you for the equity you earned because you weren't in business. to qualify for that, you have to live in the home for 2 years to show that you're your primary residence type thing. You're not a business. But the businesses, the institutional investors, they're dealing with capital gains tax all the time. This doesn't impact any of that for them. Doesn't make a difference there, but that's a good question about when that applies. This one was interesting to me. This one was more to put in here and say, kind of curious what your thoughts are again, to kind of look to start to see impact. So this one is an election thing. It's granting a new power to the government that hasn't existed before. Just want to make sure I'm showing you the important thing. It's a little long. But what it's saying.
Sounds bad.
We already like it.
What it's saying is, so it's talking about non-binding opinion questions specifically. And you say, what's a non-binding opinion question? And then it says that they're supposed to put these non-binding opinion questions on the ballot. But when you go down, they're saying this is Title 36. Let's see if Title 36 pulls up here. Here we go. And it says, so this is saying this chapter 16C, non-binding statement. It says it's enacted to read. So that's letting you know it's all brand new. If they were changing existing law, I'd say amended. This is enacted. So a non-binding opinion question means a question or series of questions, including each possible response to the question or series of questions. Now, the possible response, just to be clear, is that the legislature determines is possible. For the sole purpose of determining the opinion of the voters upon the matter. So what happens is the government is now allowed to submit a non-binding opinion question to the legal voters of the state. So they can start to do surveys in your ballot. They can start to do surveys in your ballot. So it will say, so your ballot will say, should Utah do a tax increase? We want to know how you all feel. Should Utah crack down on immigration? We want to know how you all feel. Do you think it's good or bad to start to have lists of non-binding opinion questions the legislature is asking us on the ballot? Surveys. It's a cute name for survey.
But that's kind of misnomer. I mean, non-binding just means they don't have to, but they can.
Non-binding means yes or no doesn't make it that way. So if I say, yes, I want that, it doesn't mean it will for sure happen.
No, I understand it won't for sure, but it means that they could, right?
They could.
If they ask a question and a bunch of people say, yeah, we'd like to do that, so it just happens, or?
No, they'd have to propose a law still after.
Okay,
So it's a true survey in that sense.
okay.
So your vote's not going to make it happen or not happen. There has to be a subsequent action. I'm curious if you like that power for them to conduct surveys through the ballots where you're voting for other things. Well, this is one again I'm curious about. I've seen some heads say no, seen some say okay.
Yeah, we don't need advertising, we've got people that advertise when they send out ballots. We don't need all that, just have a clean ballot.
Okay, so we have an issue, a pretty serious issue with potential voter confusion. A lot of people have no idea it's real or not real, survey, not survey. And if the ballot gets longer and longer and longer and longer, it's a concern, right? Voter fatigue, that type of thing.
So right in the middle of all those surveys is a real.
Constitutional amendment,
Real amendment.
yeah. It starts to get a little concerning about the games that might be played. Another one that's highly concerning to me is, let's say it's just a really bad thing. And we're up trying to fight it, and the subsequent thing, they're like, look, Austin, 70% of Utahns said they wanted it. I say, yeah, but your choices were very poor choices. It was, you only, you know, my kids are always, if you had to choose between one or two,
Yeah.
which one would you choose, Dad? And I go, to me, it feels so strong that they can start to manipulate it to get all these survey responses on the taxpayer dollar with very poor choices in it. That concerns me a lot. Where they're just now, oh, sweet. Because it says in here, they're supposed to submit the language of the non-binding opinion question, a statement directing. There was another one that said, let's see, that they had to submit the, I guess it's here. Yeah, so the question includes the possible responses.
Who decides what the questions are?
The legislature,
They
It's-
come with a list of
they come up with a list, yep. And they submit it. So my, oh, we had a representative in the House. He's not in anymore, but he would send out surveys to us. And it was painful how clear it was of what he was trying to get people to respond to with them. And it would be like, you'd have something on education, for example, and he says, do you support making teachers work for no pay? No. And he's like, see, everyone wants a pay increase for teachers. Like, no, you didn't ask me if I felt their pay was fair right now. He just said, but it was wild just how poorly worded it was and things. So when you're talking to me about, should we give the politicians just free access to the ballots to poll Utahns with questions they make up? They're going to use them against us.
I think the bigger problem to this too is surveys should be random. You shouldn't have a name attached to a survey response. Now everybody's name's directly attached to your response.
That's a good point too. That's a real interesting point. We have to attach it for purposes of voting, right? But a survey response, that's interesting. Do I want my county clerk who, Utah County Clerk openly admits to looking at ballots? There's another law proposed this time to make that illegal, but still, it's going through. Are you concerned about that? Do you vote a certain way because of that fear? It's not private. I agree. That's interesting. So, this one
160 or something.
is 165.
I guess the big question is why do they want to be able to do this? I mean, I just don't trust those people. So I don't believe this is, they're doing it for our benefit. I think they're doing it for their benefit.
Well, again, that's to me why I say they're going to say to me, Austin, 70% of Utahns said they want it. Austin, all the people in Utah want the NHL here. Austin, they all want the Olympics here. They're fine with us spending billions of more dollars. Well, what were these survey questions exactly? Let's go through and actually drill down. Did you ask them if the Olympics had $1 billion tax increase on it? Do you want it here? That would have been a different result than the questions they were asking.
Yeah, we changed the flag by the-
So the flag was, they had votes they put up all these different designs and you could go vote type thing. They're doing that with the hockey too. How nice of them. It's a little funny, vote on the name. We're the Utah Hockey Club for the first year. We'll sell all of our gear and then we'll pick a name and do something different the second year. It's supposedly based on voting, but the voting's closed. They still haven't released what it is. So there's still something else going on behind the scenes. Who knows? But yes, we do really unique things. I don't know why we do it all. But generally, we go to statistics and studies to then say, well, it's got to be this way because they said X. And I view it as the legislature most of the time doesn't care what we think about things. And the only time they're going to go to a survey is when they're trying to convince us that we want it.
Good point.
Because if we want it, they're just going to pass it, right? There's no need for a survey. So again, I didn't love this personally.
Well, that kind of happened with amendments, this last ballot. because they had the amendments that weren't constitutional. But the bill had already been,
I've been printed.
it had been printed, and, but so they said, well, it's not gonna, like, whatever is voted on won't happen because it's not constitutional anymore, but they kind of got a whole survey of 3 different amendments of how people felt about it, because people were like, oh, it's an amendment I'm voting on. For most people, I mean, some people knew, but a lot of people just were like, oh, what am I voting for? Okay.
Yeah. Yeah, they could have a pretty good idea of how Utahns felt about those amendments based on the results that came in. Even though they weren't, valid. And maybe they love that. They're like, oh, wish we could do this every time. Let's get this non-binding. I kind of wonder if that sparked the thought for this of, oh, this is super helpful. I think. So, and we'll skip a couple of them due to time. This one, I have concern for. You said your delegates. This is the one that's will effectively kill the caucus and delegates here in Utah. And they did talk. So we had talked about this a little bit yesterday. You had asked, there was a KSL article where they did clearly say why they're doing it, and it's part of the plan for what they're doing. So it's not just kind of out there. The ballot signature amendments, what it's doing, if we come on down, this one's actually very difficult to figure out what's happening in this bill.
Intentionally.
I don't know, because the KSL article, they were very open what they were doing. So it's just the way the law is written, they have these terms of qualified political party. I was trying to read the law to understand what a qualified political party was. It's going, who are they talking about? Which political parties are these? And I finally just Googled qualified political party because the legal definition was so bizarre. And the lieutenant governor's office said, oh, a qualified political party is defined in this law. In short, it means a party that has both a convention and a signature gathering route. Okay, thank you. That's what I needed to know. So we're talking about qualified political parties. And what's happening in this law, you'll see here, they actually make it a little less. So it used to be you had to get 2% of the subdivision if you're gathering signatures. They've changed it to the lesser of 2% or the number of signatures that a member of a qualified political party must collect to obtain. So the Republican Party is a qualified political party. They have a convention. They have a signature gathering route. And they say specifically this. Currently in the law, if you want to run for a statewide office, governor, attorney general, senate, you have to get 28,000 signatures, which has effectively made it so that the rich candidates can get those and always be on the ballot. So there's a complaint that's come up that said, hey, we got to get rid of signature gathering because it favors the rich. Go back to the caucus system like it was. And Utah has kind of the opposite response. They're like, okay, we're going to address the rich thing. We'll make it so that anyone can get signatures. And so they've dropped this number for the non-qualified parties. So these are parties that don't have a convention, but just do signatures only. That's some of the third parties. You go on down, we'll get to the blue part. And one of the reasons there's a lot of black, this is the law that's staying the same. They have to put in the whole section. Whatever section is being changed, they have to put the whole thing in. If they're not changing the words of it, it stays just in black. But you see here, here's the 28,000 for Congress. It was 7,000 for state Senate. It was 2,000 for state House. It was 1,000. Those are all axed. And they're proposing instead that it goes from 28,000 to 1,000, 7,500. State auditor, state treasurer, only 200. State Senate goes from 2,000 to 200. And state house goes down to 100 instead of 1,000. And state board of education 100, county the lesser of 50 or 3%. So apparently there's some counties where that's more than 3% of the voters.
Oh, my.
So
50 votes. Okay.
Maybe not in the same county though.
So that would completely
No, that's
almost
true.
eliminate the caucus system then.
Correct. And why is that?
Anybody who just did hundreds,
Correct.
why even, that's.
Yeah, no one will care, but the results of the caucus won't matter a single bit, right? And so why would you go as a delegate to spend time to vet candidates if everyone can get signatures? Now, what's the other big problem with this? You could have 20 people on the primary ballot going out to all Utahns.
They don't even research the ones that are on there now, which that's funny.
But again, we talk about voter fatigue, we talk about these things. So is this going to embolden or hurt big money? I think it makes it more powerful because if you're the candidate that can advertise the most, you still win, right? You can win though with 5% of the vote if there's 20 candidates. And you're now the one that goes on to represent the whole Republican Party. There's no check or balance. Anyone can declare and get signatures. And again, they can do it they can do the signature gathering and try and get the 28,000. But there's still a little bit of a limit there because not everyone can do it. And so the convention still matters somewhat because then you have a convention candidate against a signature candidate at least. But they openly say, yeah, we've heard complaints about the big money, so we're just gonna make it so everybody can qualify for the ballot.
So there's no bill currently to just eliminate.
No, they won't do that.
Why?
They love the signatures.
People that are like, ones that got signatures.
The people that are elected won't make it through the convention. So I've heard, someone told me, sorry, what's that? Oh, yes, thank you. So the question was, is there a bill to separate the lieutenant governor from the election? I've heard a lot of talk about it. I haven't seen a bill yet. But I anticipate that the most controversial bills won't come out till a little bit later on. Because they don't want to give people a lot of time to talk about them. So. With a third path? Yeah, I haven't heard about that one, so it'll be interesting to see what comes up. But this one, so Mike Lee, our senator, supports getting rid of the signature gathering route. But yeah, Cox knows he's not going to get through a convention. So he's not going to sign that. You could still override a veto, but a lot of the people up there know they won't get through convention either. And so this is a route where this is an interesting thing, kind of power play, because we have the Supreme Court case, the Utah Supreme Court case from July that said the legislature can't overturn a bill that the people passed through a ballot initiative that changes the form of government. We could do a ballot initiative and get rid of signatures completely. And they can change it based on the Utah Supreme Court's precedent. But so far, no one's jumped on that. We still could. There's time.
How do you do ballot?
How do you do it? It's painful. But no one's jumped on it. You draft your language for the bill. You submit it to the lieutenant governor's office for a ballot initiative. They issue you a form, whatever. And then you have a certain amount of time to go get about 129,000 signatures from registered voters. You have to have a certain percent from all counties. So you have to touch all the different counties and things. And there's very few that made it through without a lot of money behind them. It's a lot of signatures. The flag people's worked super hard, had a lot of volunteers, and they got up to 80 or so thousand recorded signatures. The flag, trying to overturn the flag. And they give you a very compressed time frame to do it in. So you kind of have to have a lot of people, but there's a lot of people frustrated about the signatures. And so I personally think it might be possible, but it still takes someone that's got a little time to organize and get a bunch of volunteers out, gather signatures.
So we sure don't want this.
This would completely kill the convention caucus. And it makes it kind of far more democratic, far more jungle primary like, which there's a push to take Utah to jungle primaries. But if you have 10, 20 people on the primary ballot, I don't know. You start to get some really unique results.
That is, trying to extend ranked choice voting 12 more years.
Yeah, so you're saying there's a bill to try and extend ranked choice voting 12 more years. Yeah,
Instead of, I mean, every year we try and get rid of it. They don't understand, no is no. But that would make sense that this comes into play.
yeah, because the one thing to turn it into that, because what I think they'll do is my vision. And so what's happening right now is they're saying, hey, look, everyone, the caucus system's broke. It's just producing candidates that people won't vote for. So the candidates chosen in the convention route, they're not winning. So they're going, the convention's producing this, skewed result. And I say, well, that's not entirely fair because you came in and passed SB 54, the signature route, that changed how Utahns approach caucuses and conventions. Because if you're a Cox supporter, you have no incentive to go to the convention because you know he's going to get 28,000 signatures. So the conventions do become skewed with those that still care about something certain in particular. But if we took away SB 54, we took away signatures, then everyone would have a lot more incentive to be involved in their caucus and convention. But so what they did is they passed SB 54, they wait 10 years and they go, oh, look, we're not electing your convention people. And what they're going to do, I think, with this is they're going to pass this, and then Utahns are going to be sick of having 20 candidates on the primary ballot and people winning with 5%. They're going to go, oh, we've got to go to ranked choice voting.
That's why they're extending it out so long.
Yeah, and to me, it's a piece by piece thing to get these next steps in, because as you suddenly flood a primary ballot with tons of people, you have to have a way to start to do either a second election, a third election, or else you're getting people winning with 5%. They know the public outcry from that. And it's going to, I think, lead to this. I view it as very intentional steps. They're breaking the system and then like, oh, it's broken. Look what we have to do now. I go, no. You broke it. You can't say it doesn't work once you've broken it. But that's what they're doing. They're telling us our system doesn't work when they broke it. So anyways, but I wanted you to see that one for sure. And again, this one again was hard to understand because you had to figure out the qualified political party meaning to know who it was talking about. And that was, I'll admit, for me as an attorney, it was difficult to figure out until I went to the lieutenant governor's website and they told me who it was talking about.
Legislature, a representative. I mean, would it be worth our time to talk to our legislature about it and say, we want a bill that eliminates SB 54? Or do you think it's not even worth it because
So
oh yeah.
what I would say is you have to try to do the right thing.
Yes.
They would say no,
But I will
20 other.
tell you my honest opinion. They don't care. They're going to keep signatures. It's because when you look at the news, so Senator Bramble, he didn't run for re-election, but he was the most powerful senator up there, basically controlled everything. And if he said yes to something, basically pass. If he said no, it would die type thing. He didn't run again, but he's still very involved, setting policy or whatever. And KSL interviewed him, and he's the one saying, this is why we need it. So he's still a powerful figure, and he's telling the Utah legislature, this is why we need it. Now, when we met last week, I did say, something like 80 to 85% of the time when you talk to them, they'll do the right thing. But there's a 10 or 15% of the time where they're just going to do whatever they do. I personally believe this is a situation they're going to do whatever they do. Yeah, and I'm not trying to sugarcoat anything. I still say we tell them we're very frustrated by this, and don't do it. But they have their legislative priorities. They've already met, talked about those. And when Bramble was on KSL talking about this, I went, oh, this is one of their things they've chosen to move through. So, yeah. Yeah. To tell us, oh, we're here to eliminate the big money thing. Now everyone can run and be on equal footing with Cox.
They don't think of the consequences.
Yep,
This is the House bill or Senate.
House bill.
So, like you ran as an independent, how does this
193.
affect you at all?
So what they did here, they changed the numbers to the same number of signatures an independent needs to get on the ballot. So they modeled it after that. Independence, the only way to get on the ballot is through signatures because there's no party, there's no convention. But no, it doesn't change independence necessarily. Independence still wouldn't have a primary. But it's the exact same thing where now, the one thing it could hurt, I guess, is that the law currently says, and they do have, they're talking about whether they change this. The law currently says you can only sign a nominating petition for one candidate for the office. And so even in the 28,000 realm, one of the big problems they had is you had to be first out, because if you were third out, everyone had already signed for someone and they couldn't sign a second one. And so an independent may have a harder time if there's 20 candidates running for the Republican position. They may not be able to find people that haven't already signed for that position. That would be the one potential impact, unless they said, because they did say, yeah, we're thinking about making it so you can just have one packet with everyone in it and they can just sign for whoever they want. And so if they did that, then it wouldn't impact them. That's a good question. But any other questions? We're at time. Want to make sure that. Okay, great question. Yeah, so difference in impact between a House bill and a Senate bill. In Utah, there's none. No difference. At the federal level, the House has to originate spending bills, so the Senate can't originate a spending bill at the federal level. But here, there's no difference. It's just which body chooses to introduce it.
That one body can actually kill the bill by not voting for it.
Correct, yeah.
No matter
One can
what.
kill it. The Senate tends to be the one that kills it more. The House tends to be a little more pass everything, and the Senate clamps down a little bit tighter than the House in Utah, for whatever reason. So the Senate's usually the more difficult challenge. If you can start in the Senate and get through it, chances are pretty high the House will also approve it. But it's not the same going from the House to the Senate. So, but yeah, but thanks for coming. Again, we're gonna go through on Microsoft Teams. We'll spend about an hour a week just trying to go through bills kind of quickly. Talk about some highlights from them. You can tell me which ones you want to do. If you want to get that link, let me know on the sign up sheet. There's also believe wristbands. I love to tell people that I believe. So even though I don't believe they'll change this law, I still believe we can do good. Fix some things. We don't give up and keep training. But I appreciate you guys coming and spending your time.
Thank you.
Thank you.
So thanks for being involved.
All the chairs.
Yeah, the chairs go on the ones with the wheels. Yeah.
Take your time and all
Yeah,
that
you're better next.
What was your name?
Pardon me.
What was your name?
Sure.
Funny.
Shirley.